All rise. The Ashland County Township Police Court is now in session. The Honorable Judge Janet Burnside presiding.
You may be seated. Thank you. Good morning, ladies and gentlemen. We go on the record today. I'm calling the state of Ohio versus Howard Dwayne Walters. This is Ashland County Common Pleas Court case number 23 CRI 188. Mr. Walters, how are you today? Good to hear that. Mr. Walters is here with Mr. Mayor.
Judge, would you prefer Mr. Walters to remain seated or standing for the hearing?
I really have no preferences. I will not be offended or concerned if he chooses to remain seated or stand at any time.
Thank you, Judge.
Thank you. And representing the state of Ohio is, of course, the Ashland County Prosecutor, Mr. Tunnell. So, ladies and gentlemen, the court's understanding that two sides of this case have arrived at a plea bargain agreement. And I want to ask Mr. Tunnell, our prosecutor, to first present what charge or charges the defendant has to plead guilty to if he wants to accept the plea bargain.
Thank you, Your Honor. Good morning. The state will be in keeping with the plea agreement and pursuant to that written plea agreement of the parties, is dismissing the felony murder specification as to counts 1 and 2. The state will further be dismissing firearm specifications to counts 3, 4, 5, and 6. It is the expectation of the state that the defendant will plead guilty to all counts contained in the indictment and the remaining specifications to those counts. Further, the parties have discussed and addressed the issue of merger and are prepared to advise the court that count 2 and the firearm specification thereto merges with count 1 and the firearm specification thereto. Count 3 merges with count 4, and count 5 merges with count 6. The state elects to proceed as to count 1 with firearm specification, counts 4 and count 6, in addition to the counts that are unaffected by merger. Further, and the plea agreement sets forth the specifics as to sentencing that the state and the defendant have agreed, pursuant to that plea agreement, to an aggregate sentence of life in prison with the possibility of parole eligibility after 33 years. Thank you, Your Honor.
Thank you, Mr. Tunnell. So, Mr. Mayor, on behalf of the defendant, was that the plea arrangement and bargain presented to you, Mr. Walters' behalf?
Yes, Your Honor, that is exactly our understanding. I have had plenty of opportunity to meet with my client at the jail to discuss that, and he has signed all of the appropriate documentation is prepared to waive his trial rights and move forward.
So, Mr. Walter, do you feel you understand the plea bargain that's been offered to you?
Yes, ma'am.
Okay. So, and it's court's understanding that the parties have entered a written plea agreement. The agreement was signed, as I understand, here in court today. The agreement is 5 pages long. So, Mr. Walters, did you sign this plea arrangement this morning?
Yes, ma'am.
And you did have a full opportunity to talk to Mr. Mayor about all of that?
Yes, ma'am.
And of course, Mr. Mayor, this is your signature here,
Yes, ma'am.
and Mr. Tunnell, yours here.
Yes, ma'am.
Okay. And you feel that you fully, well, the other thing I should mention is that Mr. Walters, there were certain points of this agreement out of the margins that called upon you to place your initials at certain critical points, and I see some initials here. Are those all yours?
Yes.
HW?
Yes.
Okay. Any questions at all about the plea agreement you've signed, sir?
No.
Okay. Well, the plea agreement, from the court's review, is of course consistent with the representations of Mr. Tunnell and Mr. Mayor. And notwithstanding the written plea agreement, Ohio law requires that I address the defendant personally and ensure that he understands all of the arrangements and agreements and things, ramifications of the sentence. So, assuming, Mr. Walters, that you do want to enter this plea arrangement today here on the record, tell me how old you are.
I am 60 years old.
How far did you go in school?
I earned a doctorate.
So, sufficient to say that you can read and write English.
Yes,
Are you a sober individual today?
yes, ma'am.
Does the doctor have you on any medicine?
No, ma'am.
Has there been any medicine prescribed for you currently, but you were not able to take today or last night as you should have?
No,
Do you have a history of mental or emotional problems?
no, ma'am.
So what is your mental state today? In other words, do you feel that you're able to make strong, healthy legal decisions for yourself?
I do.
Obviously, Mr. Mayor thinks that you can, or he wouldn't have you out here on the record. And you did today, one more time, go over the plea agreement with counsel, Mr. Mayor?
Yes, ma'am.
And you discussed this agreed recommended sentence that you're presenting to the court on how you would be sentenced if you pled guilty.
Every word of it.
Thank you. Relative to signing the plea agreement this morning, did anyone threaten you in any way to get you to sign it when you didn't want to?
No, ma'am.
And anyone promise you any extra or side benefit from signing it over beyond what the state of Ohio has promised you?
No, ma'am.
Because the state has promised you some things, right?
Yes, ma'am.
First of all, the first thing we heard from Mr. Tunnell this morning is that they were dismissing the felony murder specifications, which of course has important ramifications for the potential sentence here. And of course, they are getting rid of some firearm specifications and agreeing to merger and so forth. Understood?
Yes.
So anyone else promise you anything else to which you plead guilty or to sign this plea agreement today?
No, ma'am.
Thank you. And do you understand that pleading guilty is like giving me a speech? Judge Burnside, I did all of these things they accused me of in the indictment, and I agree, I did, I'm guilty. Do you understand that's what it means?
I do.
And you understand that as good as the plea bargain may sound, you have an absolute right to reject it. Even though you've signed the plea agreement, if you wanted to reject it here this morning before we conclude our proceedings, you could do that. Understood?
I understand.
So even though you have a plea bargain, as good as it may sound, you have an absolute right to reject it and say we're not guilty to all the original charges in the indictment and go to trial. Do you understand that?
Yes, ma'am.
And you understand that if you plead guilty, you're giving up all your constitutional trial rights that we're going to go to in a minute.
Yes, ma'am.
And let's talk about those. First of all, you have a right to pick a trial, whether you have a judge trial or a jury trial. Understood?
Yes.
And of course, you always have a lawyer. If you can't afford one, one's appointed, no cost to you. Understood?
Yes.
In fact, in this kind of case, 2 lawyers would be appointed to you if you're able to afford a lawyer. Understood?
Yes.
And you understand that at trial, you are presumed innocent. The burden's on the prosecutor. They have to come in with evidence and witnesses. They have to prove guilt beyond a reasonable doubt to each and every offense. If there's any offense, any charge in this indictment, they cannot prove beyond a reasonable doubt you would be acquitted of it. Understood?
Yes.
You, of course, are eligible to take the witness stand in your own defense, but you have an absolute right to stay off the witness stand No one can make you talk or even comment on your silence. Do you understand all that?
Yes, ma'am.
And you and your lawyer get to cross-examine all the witnesses the state brings in at trial to build a case against you. Understand that?
Yes.
And you and your lawyer can issue subpoenas to get your trial witnesses here to testify in your defense, and the court will enforce those subpoenas to help you get your witnesses in here. Any questions about your trial rights?
No, ma'am.
Any questions at all about the proceedings in this case?
No, ma'am.
You've retained Mr. Mayor to be your counsel. Are you so far satisfied with his advice and services?
Yes, ma'am.
At our various proceedings, pre-trial conferences, I often asked you if Mr. Mayor was visiting you in county jail, and you told me yes each time. That was accurate?
Yes, ma'am.
Okay, thank you. And so, Mr. Mayor, are you convinced that Mr. Walter is prepared to, and, well, first of all, that he's knowingly, intelligently, and voluntarily executed that plea arrangement today?
Yes, I am, Judge. Like I said, we've had many opportunities at the jail to discuss his options with respect to trial and not. Once the negotiation began to pick up toward the end of the last calendar year, the beginning months here of 2025, kept him advised, and I am quite confident that he understands everything that he is entering into an intelligent and voluntary plea. Yes.
Thank you, sir. And also one more thing, Mr. Mayor.
Yes.
Has the state of Ohio given you all the discovery and trial evidence and exculpatory information that you requested, at least to the best of your information and knowledge?
Yes, Judge. Throughout the process, Mr. Tunnell and I have been in close contact, and anything that I have questions about, he was quick, responsive, and I am confident that I have all the discoveries and that I have had ample time to review everything and help my client arrive at a good decision today.
Thank you. So, Mr. Walters, let's briefly go over the accusations against you that in each of amended count 1 and 2, the accusation is aggravated murder. Two different formulations, however. In count 1, they claim that you, in January 2023, here in this county, purposely and with prior calculation and design, caused the death of Kurtis Harstine. Do you understand that charge?
Yes, ma'am.
And then in count 2, same claim of aggravated murder, except the formulation is that you, on that date in this county, purposely caused Mr. Harstine's death while attempting to commit and fleeing thereafter from the offense of aggravated burglary and or aggravated robbery. Do you understand that aggravated murder charge?
Yes, ma'am.
Each of those charges are accompanied by 3-year firearm specifications claiming that you committed the specific offense at a time when you had a firearm on about your person or under your control, when you committed the offense and you displayed the firearm, brandished it, indicated you possessed it, or used it to facilitate the aggravated murder. Do you understand those firearm specifications?
Yes, ma'am.
Now, in count 3 and 4 of the indictment, you were accused of aggravated burglary. Again, two separate formulations of aggravated burglary. In count 3, the accusation is, again referring to January 23 in this county. They claim you by force, stealth, or deception trespassed in an occupied structure or separately secured or occupied part of one. When Mr. Harstine, a person other than your accomplice, was present, and you did this with a purpose to commit in the structure or occupied part of one any criminal offense, and they had in mind aggravated murder and or murder or aggravated robbery, violence, assault, or theft. And you inflicted or attempted or threatened to inflict physical harm on Kurtis Harstine. That's the aggravated burglary charge in count 3. Do you understand that?
Yes, ma'am.
In count 4, the aggravated burglary charge is similar only, it claims that you, on that date in this county, by force, stealth, or deception, trespassed in that occupied structure when Mr. Harstine, not your accomplice, was present, and you had a purpose to commit there any criminal offense, and you had a deadly weapon, specifically a .45 caliber firearm, on about your person or under your control. Do you understand that aggravated burglary charge?
Yes.
We go on to count 5. Here the accusation is aggravated robbery, claiming that in January 23, in this county, you, in attempting or committing a theft offense or fleeing immediately thereafter upon Mr. Harstine, you had a deadly weapon, namely that .45 caliber firearm, on about your person or under your control, and you either displayed, brandished it, indicated you possessed it, or used it. That is aggravated robbery in count 5. Do you understand that charge?
Yes.
In count 6, is also an aggravated robbery charge, different definition, however. Again, same date, this county, the claim is that you, in attempting or committing a theft offense or fleeing immediately thereafter upon Mr. Harstine, you inflicted or attempted to inflict serious physical harm on him. Do you understand that aggravated robbery charge?
Yes.
Now, we move to counts 7, 8, and 9. These offenses are all accusations of tampering with evidence under the same statute. They each accuse you of, on specific dates in January 2023 in this county, of knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, you altered, destroyed, concealed, or removed any record, document, or thing with the purpose to impair its value or availability as evidence in the proceeding. And in count 7, the evidence they allege you tampered with was a cellular phone belonging to Mr. Harstine. In count 8, it had to do with a red or orange jacket belonging to you. And then in count 9 was the accusation that you deleted certain text message communications. So do you understand those 3 tampering with evidence charges?
Yes.
So, same with the tampering with record charges, tampering with evidence charges. These are each felonies of the 3rd degree. And typically, felonies of the 3rd degree carry maximum sentences of 36 months. You can get 9, 12, 18, 24, 30, or 36 months. For each of those 3 third-degree felonies, and it's the court's understanding of the plea agreement that the agreement is that you should receive a sentence of 30 months in prison for each of those 3 tampering with evidence charges. You understand all of that by way of penalties?
Yes.
Going back to counts 3, 4, 5, and 6, these were all felonies of the 1st degree, and 1st degree felonies carry maximum sentences of a minimum term of 11 years in prison. You actually can receive generally 3, 4, 5, all the way up to 11 years in 1-year steps for 1st degree felonies. These particular felonies are now under Senate Bill 201 subject to indefinite sentencing. So the procedure is that the court selects a minimum prison term to serve, and you go to prison with the presumption that you will be released at the end of that minimum term you're sentenced to. However, the Department of Rehabilitation and Corrections in prison can rebut that presumption make specified determinations relative to an offender's conduct in prison, their rehabilitation, threat to society, any restricted housing, and their security classification, and make specified determinations, rebut the presumption, and maintain an offender's incarceration after the expiration of a minimum term or before any presumptive earned early release date, and determine that they determine to be reasonable. So that then extends the person's time in prison. Before the offender is released in that situation, they serve the reasonable additional amount of time, and the department can, once the presumption is still that the offender will then be released from prison, the department can again make specified determinations about the presumption and maintain the offender in prison for an extended reasonable period of time. This can go on, in other words, multiple times, but there's always a maximum prison term. So generally speaking, the maximum prison term is 1.5 times the minimum sentence that the court selected. And it is, of course, presumed, and it is the case, that an offender must be released at the end of the maximum prison term. So, for example, it means that if you receive the maximum minimum term of 11 years for a first-degree felony, then on half of that, maybe 5.5, you can be held as much as 16.5 years on that first-degree felony. Now, and under the plea agreement arrived at with the state, calling for an agreed and recommended sentence, it would be the parties' agreement that your minimum term is 10 years for the first-degree felonies you had sentenced to, which would then track to 1.5 being 5, a maximum term of 15 years. So if you plead guilty to all 4 of the first-degree felonies, the court is going to merge so that you get only 2 sentences for one, count 4 aggravated robbery and count 6, that's aggravated burglary, and count 6 aggravated robbery. And that you be sentenced to, for each of those, concurrent terms of minimum term of 10 years up to a maximum term of 15 years. My apologies that Ohio law is that complicated. But do you understand that first-degree felony sentencing?
Yes,
ma'am. Now, having said all that, which I am obligated under Ohio law to go over with you, because Ohio law applies to that, in your particular set of circumstances, there really is not an expectation that that process will be used for you. Why? Because it's proposed that you plead guilty to 2 counts of aggravated murder that would merge into 1 count, and that carries a potential life sentence, and therefore in prison they would not be going through that procedure I just described. And since Ohio law says I'm to describe it to you, I describe it to you, but I don't mean to take away from the fact that all of that is going to be trumped by or superseded by a 30 plus 3 years imprisonment sentence. So going back to each of these aggravated murder counts in counts 1 and 2, aggravated murder in the state is punished by a sentence of 20 years to life, 25 full years to life, or 30 full years to life, or life without parole. So the maximum sentence is life without parole under the plea agreement. If you plead guilty to counts 1 and 2, it will merge into count 1, and you would be required under the plea agreement to plead guilty to 1, 3 with firearm specification. So that your sentence would be first to serve a 3-year mandatory sentence on the firearm specification, and then begin serving a sentence of 30 full years to life. In other words, a life sentence with parole eligibility after you've served 30 full years. So that would be 3 years mandatory followed by 34 years to life. Understood? Term full in these sentences is a reference to the fact that you are entitled to all of your day-for-day jail credit since your original arrest. But full means you get no earned good time or similar in-prison credit. I wanted to recognize that these first-degree felonies and these third-degree felonies are also normally subject to something called post-release control, meaning supervision by the parole board after you leave prison. Post-release control applies to these counts for 6, 7, 8, or 9. However, again, because you'll be serving a life sentence, your leaving prison will be subject to your serving the minimum time, and then your application to the parole board for their release from prison, should they choose to do so. Do you understand all that?
Yes.
So, again, I'm going to go backwards to this. There is post-release control. We don't expect it to take effect for you because you will be talking to the parole board about your release, serving life sentence. The post-release control is optional up to 2 years. For third-degree felonies, it's mandatory 2 to 5 years on the first-degree felonies, and that supervision coming out of prison where you'd be subject to that would require reporting to a parole officer violations and result in return to prison for up to 1/2 the term you're sentenced to, and other sanctions, and of course any new felony committed on post-release control can be the subject of a new consecutive prison term of greater than 12 months at the time remaining on post-release control. And now is another good time to apologize to you for the complexity of Ohio law and sentencing. Let's talk about fines. Fines for the offenses it's proposed to plead guilty to is $25,000 for aggravated murder. It is $15,000 for felonies of the first degree and $10,000 for third-degree felonies. And I should have been saying up to $25,000, up to $15,000, up to $10,000. And of course, the court does typically enter judgment against the defendant for court costs. So it is the court's understanding that before we came out on the record here today, Mr. Walters, you and your lawyer went over a written waiver of your constitutional rights and your guilty pleas. And in this document, there was a description of all of the charges and specifications that you were planning to plead guilty to. Part of the plea bargain. There was also a written explanation of all of the maximum penalties, which I believe my explanation conformed using far-long words, unfortunately. That's contained in this document as well. And there's other representations here about court costs and post-release control and so forth. And it also is contained here your recognition that you understand the presumption of innocence, the right to the jury trial, and the other constitutional rights. So I see that what appears to be your signature is at the bottom of this agreement. Did you sign that, sir?
Yes, you did.
After consultation with counsel? Any questions at all before we go? Follow. Okay, thank you. So, relative to count one of the indictment, aggravated murder, do you understand the charge and the penalties?
Yes,
How would you like to plead to that?
I'm guilty.
And on the 3-year firearm specification that accompanies that charge?
I am guilty.
And on count 2, aggravated murder, do you understand the charge and the penalties?
Yes,
And how would you like to plead?
I'm guilty.
And on the 3-year firearm specification on that charge?
I'm guilty.
Now we move to the first degree felony count 3, aggravated burglary. Do you understand the charge and the penalties?
Yes,
And how would you like to plead?
guilty.
And with respect to the count 4, aggravated burglary, do you understand the charge and the penalties?
Yes,
How would you like to plead?
guilty.
And with respect to aggravated robbery and count 5, do you understand the charge and the penalties there?
Yes,
How would you like to plead?
guilty.
And with respect to count 6, aggravated robbery, do you understand the charge and the penalties?
Yes,
How would you like to plead?
guilty.
With respect to counts 7, 8, and 9, do you understand those 3 charges, all tampering with evidence felonies of the first degree?
Yes,
How would you like to plead to each and every one of them?
guilty.
Did anyone threaten you to get you to say guilty to me all those many times here this morning?
No.
You know that you were promised by the state of Ohio, which is reflected in your plea agreement, to enter and agree to recommended sentence and to dismiss some firearm specifications, to merge other counts. The agreed recommended sentence specifies the sentence that you would receive in each and every one. Any other promises anybody made to you that you plead guilty to today?
No.
So, the court does find you guilty consistent with your pleas of count 1 aggravated murder and the 3-year firearm specification, guilty of count 2 aggravated murder and its 3-year firearm specification. The court is going to merge, as the parties acknowledge it should, count 2 into count 1. So that means that the court will be sentencing you at the appropriate time here today to amend count 1 aggravated murder and 1 3-year firearm specification. The court finds you guilty of counts 3, 4, 5, and 6, all first-degree felonies, the first 2 being aggravated burglary, counts 3 and 4. The court will merge into count 4 and you receive a sentence there. And then the court merges counts 5 and 6 into count 6, so you'll receive a single sentence there. And the court finds you guilty of each of counts 7, 8, and 9. And and of course, the court does accept, has accepted and acknowledges the dismissal of the other firearm specification and felony murder specifications. So, on behalf of the state of Ohio, what further would you like the court to know before we sentence the defendant?
Thank you, Your Honor. The state would prefer to defer its comments until after some of the family addresses the court. We have some family members that wish to do so at this time.
Thank you. Proceed.
Thank you. This will be Janet Harstine, Your Honor. She is Kurtis Harstine's mother.
But it is the opportunity to speak to. It's my Howard. Years ago, you said to me, you just loved her. He was the son you never had. Now, it's been 2 long, painful years, and I'm still distressed to know that you murdered my beloved son, Kurt. Kurt went above and beyond to try to please your daughter. I'm aware that you were deceived and pressured into taking the law into your hands. If you would have just stepped back and taken a good look, long look at the entire situation, I believe you would have realized who the abuser really was. I was in Kurt's home for 7 years when I cared for his children before he told me not to come back. I watched the manipulation of my son to take place, but in an attempt to keep the peace, I unfortunately chose not to say anything. I watched as your entire family catered to your daughter, your daughter's every whim. No one ever called her up on it or dared to correct her. I know about the fires that you started in Kurt's garage. I know about you trying to get Kurt to move into one of your rental properties. I know from the evidence presented that your actions were entirely premeditated. It makes me wonder how long and how many times you plotted to harm my son. Did you even consider all the lives you were going to destroy, including your own grandchildren? You took a dearly beloved father, son, brother, uncle, nephew, cousin, friend, co-worker from all of us. You took a veteran that sacrificed 12 years in order to protect your rights to live free and to live in freedom. And you also deprived your own grandchildren of their grandfather. That deeply saddens me because I always thought he was a wonderful grandfather. I choose to forgive you. However, I will never be able to forget your selfish actions. No matter what punishment you receive, Howard, it will never bring her back. And I feel like if there's anybody that knew that this was going to happen to Kurt, and you didn't speak up or say anything, shame on you. Shame on you. Thank you.
Dr. Kendra Wardenkircher, Kurtis Harstine's sister.
I'm going to ask the court reporter, will appreciate you spelling your last name.
I'm reporting for H-O-R-D-E-N-K-I-R-C-H-E-R. Thank you. Oh, wow, this is sweet.
And you know, you may want to straighten up the microphone so it's a little closer to your voice. Thank you.
Is that better? Is that any better?
Yes, thank you.
Howard, I know you feel like you have done what you felt was right, but have you? You took someone who loved his family, even though he was isolated from said family. You took someone who fought for not only those he cared for, but those who struggled no matter what background. Kurt tried to help everyone that he came in contact with. He was a protector. You knew that. You knew he would do anything for his family. You knew he would still help you, even though things were the best for him. You knew he would still help you. Sorry. You took somebody so kind-hearted, he still trusted you. You took that. And you still used it to do the most unspeakable thing, the most evil thing you could possibly do. You didn't just take it from us. You took it from your grandkids. You didn't just take them. You took yourself out of their lives. No more vacations with them. You don't get to see them get married anymore. You won't get to see your grandkids as kids. I forgive you. Because you became a victim also. I'm sorry that you became a tool to the devil's actions. Now you have to live with the fact that you were taken from them. I pray that you were judged by the Lord and Christ leave you belong after you heard him. I know my brothers with his dad and all those who loved him. There are so many. I still don't feel you know the gravity of the impact you did with our act. We had so many people come to the funeral and say how much they were hurt. How much hurt he felt. Some breaking down, asking us, they have no idea how they're going to go on without his guidance. I pray that you finally see the horrible things that you did. God, tell the truth, God. Without a love. Just know we never stop loving your grandkids. We never fought for them. Just know that we won't ever look at that. There are so many kids out there who could touch their lives and wonder why this is happening. No one may forgive you, but I won't forget it. What you've done and how it's happened. What impact did you leave on this world? I don't know that you understand the impact that you have created. To be the person who takes somebody's father away from them. Somebody they adored and loved. To have that feeling of not understanding, but knowing exactly who did it and exactly why, your kids won't forgive you for that. You do that. Your kids won't. And we won't. We won't let it be. Now, you may live with the guilt. May it be heavy. And I pray you finally give up the truth and the reasons. And I hope God forgives you. That you won't forget the true people. And live the life you deserve. Thank you.
Kurtis Harstine, sister victim Kurtis.
My name is Kristen. I'm Christine's sister. I had a plan on coming up to the top of saying things to her because I truly believe that anything I have to say like, how you affected my family, or does it matter to you? You don't care. You could care less. You didn't care 2 years ago when you made the decision to go with her. You don't care now. But I just couldn't get over this feeling of saying something to you about your family. You took a great house from your 2 daughters that had no skin in the game. Taking her out didn't affect anything. You have 2 daughters that loved and cared for you, and they still do. But like, now they can't give you hugs. They can't call you up and say, hey Dad, guess what happened today? I know how it feels, because my dad was taken from me. I hope that when you're in prison, you think about that feeling that you had when you lost your mom. When your mom passed away, that feeling, that sadness, congratulations. You gave that to 2 children of hers. You gave that to your grandkids. And you gave that to your other 2 daughters that had no skin in the game. That it didn't matter to them whether her was black or not. That's what I was thinking about when you brought me in prison.
Your Honor, Earl Donnelly is the stepfather of Kurtis Harstine.
Howard Kurt trusted you and God's years of friend, and you betrayed that trust. I worry about all the veterans that Kurt was helping through the VA that are missing them now. I worry about our grandkids who lost the one decent parent they had. Your actions have cheated us out of seeing our grandkids as well. We were the only other stable, normal people in their lives. And just to set the record straight, I was the favorite. I have to watch my wife go through losing her son twice. No one should have to experience that. You had the audacity to call us and ask if we had heard from Kurt when you knew where he was because you murdered him. You hid behind a veil of religion, and now we see you were just a hypocrite. You thought you were superior to others because of your education, but now we see you're not as smart as you thought you were. You did all this based on the ravings of a delusional, paranoid, mentally unstable person whose version of the truth changes by the minute. I hope you die a long, slow, but painful death in prison. I am not an overly strong believer in the afterlife, but you make me hopeful there is a hell. The thought of you burning for eternity gives me some solace. I would ask for pity for your soul if you don't deserve it.
Thank you.
It's all been said. I don't need to speak. Thank you.
Thank you, Your Honor. There's nothing further from the victims' families in this matter. On behalf of the state would merely echo the sentiments that are expressed by the victims' families and ask that the court impose the agreed sentence. Thank you.
Thank you. So, Mr. Mayor and Mr. Walters, what would you like the court to know?
Briefly, Your Honor, ask that you propose and adopt the joint recommended sentence that has been negotiated between the defense and the state. My client, prior to entry the guilty pleas earlier this morning, presented with no prior criminal record and had, by all accounts, led a law-abiding, productive life. He has accepted responsibility by pleading guilty, and he does so at age 60 with a clear understanding of the realities of that joint recommendation and 33 to life. We're asking that you oppose it, move straight to sentencing today. I believe it is consistent with the purposes of sentencing.
Thank you. Mr. Walters, what would you like the court to know?
I am sorry for all of this pain, and I am responsible for her. That's an honor.
So the court will accept and adopt and put into action the parties' agreed and recommended sentence. The defendant is sentenced on amended count 1 to 30 full years to life. And prior to serving that, he will first serve a 3-year mandatory consecutive sentence on the firearm specification of amended count 1. On each of amended counts 4 and 6, the court imposes a minimum term of 10 years, which under Senate Bill 201 has a maximum term of 15 years. On each of counts 7, 8, and 9, the court imposes 30 months in prison. And all of these sentences will be served concurrently, with, of course, the exception of the 3-year firearm specification. I have previously described and, of course, acknowledged the presence of post-release control on counts 4, 6, 7, 8, and 9. The court awards 571 days jail credit, and we will put that number in the journal entry. And that, of course, is through today. The defendant will receive day-for-day credit after today until his arrival in the institution. But that amount will be awarded by the Bureau of Sentence and Commutation. Mr. Walters, you are notified that you may have a right to appeal and a right to have counsel appointed for that appeal and a transcript of all proceedings provided at no cost if you are determined to be indigent and unable to afford counsel, and that includes the cost of any appeal. You're advised that any appeal must be filed in writing with the court within 30 days of the court's filing of the sentencing entry in this case. Any questions about your appellate rights? Anything further on behalf of the state of Ohio?
No, Your Honor, we thank law enforcement's efforts in this case, and we thank Your Honor for sitting by his side.
Thank you. And Mr. Walters, anything further? Excuse me, Mr. Mayor, anything further?
No, thank you, Your Honor.
Okay, thank you both. Ladies and gentlemen, the court appreciates your patience and tolerance this morning. I am remanding the defendant to the custody of the Ashland County Sheriff to await transport to the state penal institution. And I believe that concludes our work here today. Mr. Walters, good fortune to you. We are done. We're off the record. Thank you.
All rise.
What's up? We're all set. Thank you.
so it'll be just a moment or two, then we'll dismiss. And again, for obvious reasons, this I suppose normally we dismiss this group first, okay?